Welcome to my channel. I am the Loud Little Ducky. Today we are going to be going over Owens v. Echard, where Owens files bar complaints against opposing counsel. And we have her drinking her monstrous drinks, chugging them, and we think that there should be no complaints. 4/8/2024. Before the presiding disciplinary judge in the matter of a member of the State of Bar of Arizona, Gregg Woodnick, his bar number, protective order. It says the State of Bar of Arizona, on behalf of the complainant, a request for a protective order sealing information protected by attorney-client privilege and/or ER 1.6, as well as login credentials for medical record from respondent and the public. The State Bar does not object to request, and no timely objection was received from respondent. Good cause appearing. It is ordered, granting the request. It is further ordered the complainant's login credential for her medical records and email communications with former counsel be sealed and kept confidential from respondent and the public pursuant to Rule 70G, Arizona Supreme Court. Sealed material shall be opened and viewed only by order of the committee, the presiding disciplinary judge, a hearing panel, the board, or the court for use by such body and the parties in the pending proceedings, and otherwise only upon notice to and an opportunity to be heard by parties and witnesses or other person who is subjected of the information. And this is dated April 8th, 2024 by a presiding disciplinary judge, and copies were sent where they needed to go. Request for protective order sealing the record. The State of Arizona, through undersigned counsel, hereby forwards to the presiding disciplinary judge of the Supreme Court of Arizona complainant's request for protective order pursuant to Rule 70G, the rules of the Supreme Court. Complainant requests that the following information be sealed from the respondent and the public: complaints, initial charges, immediate assistance and guidance needed in the response to ethical concerns and intimidation in a legal case received via email on Sunday, January 7, 2024 at 9:59 a.m. contains complainant's login credentials, username, password, and hyperlink for medical records. Email communications attached in the complainant's initial charge 12/29/23, conversation with Lexi Linval. 1/20/24, Lexi's withdrawal letter. 12/31/23, email to Lexi addressing any concerns. 12/27/23, Lexi pressure to sign affidavit. January 5th, 2024, correspondent with Linval and Woodnick. The email communications are between complainant Shane Ross and Alexis, also known as Lexi Linval, complainant's former counsel. Complainant asserts the communications are confidential and protected by attorney-client privilege. Complainant's request for a protective order, request for confidentiality. The good reason for sealing the information is the complainant provided information in her initial charge that may be considered individually identifiable health information pursuant to the HIPAA privacy rule, specific login credentials that would access complainant's medical records. Additionally, the information shared in the email correspondence between complainant and her former counsel would be confidential per ER 1.6 and also includes complainant's login credentials to medical records. The State Bar does not object to the complainant's request and the request be granted. Request. That's a lot of requests. Letter from complainant regarding protective order is attached as Exhibit A. A proposed order is attached in Exhibit B, dated 21st day of March 2024, and this is done by the Intake Bar Council. And then a copy of it was sent. Before the presiding disciplinary judge, protective order. The presiding disciplinary judge of the Supreme Court of Arizona, having reviewed complainant's request for a protective order and there being no objection by the State Bar, accordingly, it is ordered the complainant's request for a protective order is granted. It is further ordered that the complainant's login credentials for her medical records and email communications with former counsel be sealed and kept confidential from respondent and the public pursuant to Rule 70G, Arizona Supreme Court. Pre-complaint orders sealing materials do not seal such material post-complaint if the material is sought to be used or referred to in subsequent pleadings or in hearings. In such circumstance, the parties are reminded a formal request for protective order with specificity must be filled with the materials sought to be sealed and submitted for in-camera review. Sealed materials shall not be opened and viewed only by an order of committee, the presiding disciplinary judge, a hearing panel, the board, or the court for use by such body and parties in pending proceedings, and otherwise only upon notice to an opportunity to be heard by all parties and the witness or the other person who is the subject of the information. A party aggrieved by an order related to a request for a protective order may seek review by filing a petition for special action with the court. And this is by Margaret Downey, who is a presiding disciplinary judge. And this was done in March of 2024. Here is one of the exhibits. It is from Mandy Fitzgerald, and it is to the presiding disciplinary judge on Thursday, March 21st, 2024 at 10 a.m. And then they have CC'd some other people and Woodnick. Protective order request and order. Good morning. Attached for filing today is request for protective order sealing the record. A Word version of the proposed order is also attached. Thank you. Sandra Montoya, and this is from Reed Potter, Tuesday, February 27th, 2024. Good afternoon, Miss. I was in the process of leaving you a voicemail. Believe it was cut off. I reviewed your detailed submissions. As previously stated, you are currently involved in an ongoing litigation. The basis for your allegations are mostly from the pleadings themselves, which is why I'm suggesting you speak with your current counsel, Mr. Keith. Yes, go talk to Corey. Stop doing things on your own. You have an attorney. The issue at this stage for your case, the issues at this stage are more appropriately raised with the court. The court is the most familiar with the facts, rules, statutes, and case laws for your case. It is inappropriate for the State Bar to get involved in active cases. They're not going to get involved in active cases. It's just not happening. But let's flip out and contact somebody because you need this crazy train to stop before it implodes, which it is already done. Except under certain circumstances which are not applicable here. The court concludes that Mr. Woodnick acted. If the court concludes that Mr. Woodnick acted inappropriate, please provide us with a copy of that written finding for further consideration. Basically, they're not going to do anything unless the judge says, Mr. Woodnick, you're out of line. And if that doesn't happen, they're not going to do anything about this. Until then, we consider this matter dismissed and we will take no further action. Pursuant to Arizona Supreme Court Rule 71, the State Bar file may be expunged in 3 years. All right, so they're not doing anything to Woodnick in this case. All right, and then we have Gregg Woodnick telling Reed Potter, thanks, Reed. Safe guess it was from Redacted, but I'm guessing it says Owens. Appreciate you closing this. And then this is from GRW office. Or no, it's from Reed at the Arizona Bar to Woodnick. The State Bar recently received a bar complaint charge against you. I have determined the further investigation is not warranted at this time and our file has been closed. The charge is dismissed pursuant to Rule 70A4, Arizona Supreme Court. The record of this charge will be public for 6 months from the date of this email. This charge has no adverse impact on your standing with the state bar. The record shows a consumer charge that was dismissed pursuant to Rule 71, Arizona Rules Supreme Court. The state bar file may be expunged in 3 years. So Owens was told and Woodnick was told. Nothing's going to be happening. Don't worry about it. You're still good. Then we have, I'm guessing, Owens' email to the Arizona State Bar. And it says, Mr. Potter, I wanted to add my complaint and articulate my deep-seated concerns regarding the conduct of attorney Gregg Woodnick and by extension the actions of his associate Isabella Rainey at Woodnick Law. Number 1, misrepresentation and offensive allegations by Gregg Woodnick. In an email sent to my sister, Mr. Woodnick made several baseless and deeply offensive allegations. He stated multiple men have alleged that your sister fabricated pregnancies and medical documents to support her pregnancy fiction, and continued to defame my character by suggesting a pattern of deceitful behavior, including faked pregnancies as a ruse to force relationships. These allegations not only completely misrepresent my personal and medical history, but also to contravene the ethical standards regarding truthfulness in statements to others. Rule 4.1. And misconduct involving dishonesty, Rule 8.4c. I saw my sister daily on Zoom as well as in person throughout my pregnancy. She knows better than anyone that I was legitimately pregnant. Oh my God, you saw her on Zoom? Maybe with your moon bump? So she knew you had a belly. And many people think that you have used fake pregnancies to force dating relationships. It has been multiple women, and your medical documents support that narrative of Woodnick. He has very good reason to believe, just as many of us do, in this situation. It is his opinion, based on the evidence, that this is what is happening. It's not unethical to state that and to see if your sister agrees or sees it or decides to back you. You're being ridiculous. Number 2, inappropriate direct communications by Gregg Woodnick. Mr. Woodnick's email to my sister, sent to both her personal and business emails, bypasses standard legal protocols and directly involves a family member in a distressing manner, stating Laura's actions are about to land her with a very unpleasant legal consequence, including possible criminal perjury charges. This direct communication, laden with undue pressure and threats, raises concerns under Rule 4.2, communication with person represented by counsel, and Rule 4.4, respect for rights of third persons. I don't think that Woodnick threatened your sister. I think he was letting your sister know, if you know anything about it, because your sister Owens has brought you into this case, and it is not a pleasant case, and it could have legal consequences and criminal charges because of all the fraudulent stuff that has been discovered that she has done. And because she is a witness, he has the right to contact her. That's not unethical. The nature of this communication could be seen as a violation of Rule 4.4, which requires respect for the rights of third persons. By involving my sister in this manner and using language that could be construed as threatening, Mr. Woodnick's actions may have effect of harassing or malicious injuring another party, which is expressly prohibited under the rule. The actions and statements of attorney Gregg Woodnick, compounded by the public remarks made by Isabel Rainey, represents a pattern of behavior that is deeply concerning. Ma'am, you know whose actions and patterns of behavior are deeply concerning? Yours. That's who. Yours. You don't need to be worried about anybody else but yourself. Seek help. Get therapy. I believe, in violation of multiple rules of professional conduct, I hope this Arizona State Bar will conduct a thorough investigation into these matters, ensuring accountability and adherence to ethical standards expected of legal professionals. They were. And they're not going to do any further investigation because, no. Number 3, unsubstantiated public statements by Woodnick Law in media, as opposed to yours in the media. Isabel Rainey, an attorney at Woodnick Law, was further compounded by concerns regarding the firm's ethical conduct. As reported by Jimmy Jenkins in the Arizona Republic, Miss Rainey publicly commented on the ongoing legal proceedings between myself and their client. Her statement, blank, has a pattern of falsely claiming to be pregnant. The premise of our motion for sanctions is that this was all a fraud, was made in contact that suggests an attempt to prejudice public opinion and the legal process against me. It doesn't matter what the public's opinion is. It doesn't matter if they're prejudiced, because this isn't going to a jury. This is a bench trial. So the public can't be prejudiced. That's in this legal process, because none of them are coming in and deciding this, which is probably good for you, because you don't want the public or anybody with some common sense sitting in there and determining this for you, because it's not going to go well. A. Violation of confidential and prejudice to administration of justice. Such public allegations could potentially violate Rule 3.5, impartiality and decorum of the tribunal. By undermining the decorum and the impartiality of the judicial proceedings, it rises to concerns about the influence of extrajudicial statements on the administration of justice, particularly when made during ongoing legal disputes. Ma'am, this is for cases that are going in front of a jury. This is not for bench trials where judges are determining things. So maybe read up a little bit more. Watch some Law and Crime. It might do you some good. B. Misconduct involving dishonesty and misrepresentation. By publicly asserting a supposed pattern of fraudulent behavior on my part without conclusive evidence. Oh, there's conclusive evidence. She's not saying it she didn't just pull it out of her butt. Miss Rainey's statements may breach Rule 8.4c, which prohibits conduct involving dishonesty, fraud, deceit, or misrepresentations. The public dissemination of unverified claims could be seen as an attempt to misrepresent the facts to the detriment of my character and case. It has nothing to do with your case, because your case is in front of a judge. And it is not involving fraud or dishonesty, deceit, or misrepresentation. Those 4 words are used to describe you, Owens, and your arts and crafts. Did you hear that? Do I need to say it again so that you can get it through your little pea brain? C. Improper trial publications. According to Rule 3.6, trial publication trial publicity, attorneys are restricted from making public statements that could materially prejudice an adjudicative proceeding. Miss Ramey's comments to a widely read publication like the Arizona Republic risk influencing the perception of potential jurors, the public, and the other parties involved in the legal process, potentially jeopardizing the fairness of the trial. There are no potential jurors in this case. And you know that. You know this is a bench trial. But go on with yourself. The actions and statements of attorney Gregg Woodnick, compounded by public remarks made by Isabel Rainey, represents a pattern of behavior that is deeply concerning. Ma'am, you need to quit judging people on deeply concerning acts because you don't know what deeply concerning acts are, because you are not self-aware. So until you can recognize them in yourself, maybe don't speak on other people. I believe in violation of multiple rules of professional conduct. I hope the Arizona State Bar will conduct a thorough investigation to these matters, ensuring accountability and adherence to ethical standards expected of legal professionals. Thank you. All the best. God, I hate that sign off. Then we have on Friday, February 16th, 2024. Mr. Potter, I appreciate your patience and understanding regarding my complaint against Gregg Woodnick. Despite my hopes for a cessation of personal attacks in this filing, the situation has deteriorated further, with the attacks becoming increasingly vitriolic. Such behavior, I believe, is highly uncharacteristic of a legal professional. I am enclosing documents of 3 of his most recent filings, which I find contain egregious violations. While there are numerous instances I could point out, I have chosen a few quotes that I find particularly offensive and unbecoming of an attorney, which have added hours to preparation of this complaint. These quotes underscore the personal nature of his attacks against me and heighten my apprehension about facing him in a deposition. Number 1. Petitioner initiated the underlying action when she filed her petition, alleging that she was pregnant with respondent's twins after one night of oral sex. This time, petitioner chose a television personality on which to perpetuate this fraud and not only fake the pregnancy, but attempt to extort him to date her in exchange for an abortion of fictional twins. Yep. That seems like a summary of what happened. What are we misunderstanding here? Number 2, this entire action by petitioner is predicated on fraud upon the court. Petitioner continues to seek out media attention and exhaust all of her procedural remedies to evade basic discovery and disclosure obligations. Perhaps if petitioner provided the statutory required fetal death certificates and verifiable medical records to support that she was ever pregnant with twins, she would look less likely, as stated by petitioner's attorney, a crazed woman who fabricated a pregnancy. Owens says, these statements not only misrepresent the truth, but also serve to unjustly malign my character in public and professional forum. It is imperative to note that I have provided ample proof of my pregnancies in my filings prior to Mr. Woodnick's involvement in the case, which he can see for himself, countering his baseless claims of deception. For verification of my pregnancy, you may access my patient portal and see that my P-stick said I was pregnant. That's not what she said, but that is what she said. Where my pregnancy was initially confirmed. It is crucial that this information remains confidential and not be disclosed to Mr. Woodnick should this communication need to be shared as a part of the complaint process. I trust that all of these examples illustrate the gravity of Mr. Woodnick's conduct and the impact it has had on me. I look forward to your guidance on how to proceed with this matter. All the best! They are not there to give you guidance. They're there to hold attorneys accountable and keep them in check. And if they're being unethical, such as, let's see, Alex Murdaugh stealing money from clients, that. Tom Girardi stealing money. Those are unethical things that the Arizona Bar are interested in, not giving guidance to you in a case that is ongoing. And this information is going to get disclosed to Woodnick, because all bar complaints get sent to the attorneys. They get copies of the complaints. Rekieta has read his bar complaints on his live streams. It's not kept private. So, sorry, they're not keeping things confidential for you. He has the right to know. Because things, there has to be a basis for it. And if it's kept quiet and confidential, then how is the Arizona Bar supposed to figure out if there's merit to this complaint or not? Like, you make no sense. You don't know what the bar complaint hotline type place is. You don't know what it's for. Okay, and then here on the left-hand side is what we just read in one page. And then we have, as repeatedly stated in respondents' prior filings, petitioner has wantonly and willfully failed to provide any Rule 49 disclosures, respond to any requests for production, and refused to attend a properly noticed Rule 57 deposition. Petitioner has further refused to sign fetal death certificates or basic HIPAA release related to a form of medical care she testified to receiving for her alleged high-risk pregnancy. And with that mention right there, you know what else has not been mentioned recently or in any of her medical stuff that we've seen? Nothing stating that she has a high-risk pregnancy. Where is that documentation? Which doctor told her she was high risk? You'd think that it would be documented, right? It's not. Notwithstanding this conduct, respondent appeared at petitioner's noticed video deposition at her most recent counsel's office and fully participated last Friday, 2/2/2024. She showed up to Clayton's but didn't show up to hers. She's so scared of him. The issues of sanctions and attorney's fees cannot be adequately adjudicated without disclosure and discovery from petitioner, including the opportunity for respondents to depose petitioner. Again, petitioner video deposed respondent on February 2nd, 2024, after intentionally failing to appear at her own properly noticed deposition. Additionally, the 45 minutes currently allocated for this hearing will not allow respondent to fully present his position on the issues. As and for his motion to continue trial, respondent states as follows. 1. On August 1st, 2023, petitioner initiated the underlying action when she filed her petition to establish paternity, legal decision-making, parenting time, and child support, alleging that she was pregnant with respondent's twins after one night of oral sex. So that's where that came from when she put it in her thing. Number 2, respondent maintains that this alleged pregnancy was a hoax/con, much like the previously litigated matters involving petitioner and other men similarly situated. Yep, that's what's happened. Here, as with the prior matter, petitioner faked medical records as her supposed proof of pregnancy. Yep. Somebody needs to take her subscription to Adobe away from her, because she abuses it. This time, petitioners chose a television personality on which to perpetrate this fraud and not only fake the pregnancy, but attempted to extort him to date her in exchange for an abortion of fictional twins. Respondent refused to date petitioner, who then continued to promote the false narrative that she was pregnant to the media and the court system, including during subsequent injunction against harassment proceedings, where she appeared on the video in court wearing an obscenely fake pregnancy stomach, and asked Judge G to allow her to show respondent that she was pregnant. She then continued to contact the media, including the tabloid The Sun, Reddit, Medium.com, podcasters Dave Neal and Reality Steve, which is Steve Carbone, etc., furthering her entirely fraudulent fake pregnancy narrative. And if you haven't watched Dave Neal's, some of his recent videos, he shows that Owens sent him a video of her outbox, her sent mail, emails, and I don't know what she thought that would prove, because it's like, no. But it showed that she was emailing media tip lines like nobody's business, pushing this out here. So she can't say, oh, I didn't send it to the media. Yes, you did. Number 3, on August 21st, 2023, respondent filed his answer denying the petitioner could sufficiently be pregnant with his twins after they engaged only in oral sex on May 20th, 2023. 4, petitioner seems to acknowledge that no sex occurred in her bevy of 500 emails and texts, which resulted in Judge G granting an injunction against harassment against petitioner after a 2-day trial on the same. So we need to find that text where petitioner acknowledges that they didn't have sex. That's in whatever text or email that's in. We need to find that, because the petitioner acknowledges there was no sex. Then there was no ARPing. There was no intercourse. None of it. As she has told the judge, her lawyer, and her medical expert. Which I'm pretty sure Gregg and Clayton will have that, because it's like, well, here you said you acknowledged that you didn't have sex. So now you're going back and saying, no, we did. Oh, he ARPed me. But I don't want him getting in trouble for it. Like, oh my God. Number 5, nearly 7 months have passed since petitioner initiated this action, during which no disclosure has been provided by petitioner, despite the requests made to her numerous counsels in accordance with Rule 49. 6, petitioner has willfully and wrongfully failed to comply with Rule 49. Rule 49 provides in pertinent part as follows: unless the parties agree in writing or the court orders otherwise, every party must serve an initial disclosure of information required under sections D through K, not later than 40 days after the filing of the first responsive pleading to a petition. Emphasis added. As respondent filed his response on August 21st, 2023, petitioner's Rule 49 disclosure was due no later than September 30th, 2023. As of filing, no disclosure has been provided. Respondent intends on filing a motion to compel in short order. 7, on January 17th, 2023, petitioner failed to appear at a properly noticed deposition. See respondent's notice of non-appearance at deposition pursuant to Rule 57G. Notably, respondent appeared and cooperated with petitioner's video deposition on February 2nd, 2024. So a lot of repeat stuff. Respondent is unable to fully and meaningfully present his argument, for which he should be awarded attorney's fees and sanctions. Without this disclosure, she seems to know that after a myriad of conversations had with petitioner's attorney, and is flaunting her failure to provide the same. petitioner's convenient claim and effort to get the case dismissed without full adjudication by now saying she is no longer pregnant. Does not indemnify her from providing Rule 49 disclosure or participate in discovery in accordance with the rules as fully detailed in respondent's response/objection to petitioner's motion for confidentiality and preliminary protective order. To date, petitioner has provided no verifiable proof of pregnancy by respondent, the foundation basis of her original petition to establish, and despite her invocation of Rule 2, footnote 2, petitioner's counsel did offer to provide only limited disclosure at respondent's deposition, but not in a manner that would satisfy the evidentiary standards of Rule 2, which petitioner invoked, and respondent is unwilling to accept any disclosure that is not provided from the source itself due to petitioner's history of arts and crafts of medical evidence, including faking sonograms. Dun dun dun. If she did have a miscarriage, seemingly impossible as she could not have been pregnant from oral sex, it does not explain her under oath testimony with Judge G, where she displays her pregnant stomach and confirms in her testimony that she is not only pregnant, 24 weeks at the date of testimony, but under the care of multiple medical professionals for high-risk condition. And David Gringes, her Owens attorney currently, has not mentioned anything about her being high risk. There has been nothing stated about this high risk situation in months. Is that because there's no documentation on it? Probably. Simply said, petitioner's pregnancy was faked. The bump displayed in Judge G's courtroom was obscenely purchased as evidence by petitioner clearly adjusting what appeared to be a fake belly and guzzling a Monster energy drink. Curious for someone claiming to have a high-risk pregnancy. Indeed. And that is part of the reason why Owens and the Monster energy drink are the thumbnail for today. Her entire petition was predicated on either lies or delusions and mirrors prior litigation involving Owens and a growing list of other victims, at least 3 known men, including respondent. Now we know there's about 4 or 5 of them, including respondent. Number 9, respondent has complied with all requests for disclosure and participated in a video deposition as required by rules and requested by petitioner. Petitioner has provided none and continues to flout the rules of the court he invoked. Number 10, there is good cause for continuance given the wholesale lack of disclosure and discovery by petitioner. As no disclosure has been received in relation to any claims made by petitioner, including the original claim of paternity on which this underlying matter was filed, respondent has been left with an incomplete picture of the full extent to which petitioner's baseless accusations and myriad of filings have harmed him. As such, respondent requests that the hearing be continued to allow for disclosure to be received. Number 11, respondent has been patiently waiting for petitioner to provide any disclosure for over 7 months. The original claim on which this petition was filed was brought in bad faith over 7 months ago, and no disclosure to verify it has been provided. Since then, petitioner has involved several attorneys, and respondent has engaged in significant efforts to facilitate disclosure and discovery, but to no avail. As such, a continuance at this stage is appropriate, and respondent has made diligent efforts to avoid having to file a motion to continue, including several discussions with petitioner's attorneys. Neither party will be prejudiced by a continuance. This continuance is sought in good faith and not for delay, as respondent needs access to critical disclosure in order to properly litigate. As and for his motion on additional trial time, respondent states as follows. The evidentiary hearing before the court, currently scheduled for 2/27/2024, is set for 45 minutes. This allows each party less than 25 minutes each to present their arguments for the issues of sanctions and attorney's fees. As this case has been ongoing since August 2023, the issues for the hearing include, but are not limited to, petitioner's bad faith in bringing the underlying paternity action, despite not being pregnant by respondent, was impossible from oral sex. Petitioner's factual contentions / assertions of pregnancy not supported by any verifiable evidence from the onset of this action. Petitioner's wholesale refusal to participate in discovery and disclosure. Petitioner's repeated filings, including a motion to dismiss once she alleged she was no longer pregnant, being unsupported by existing law. Petitioner's unreasonable behavior throughout this matter, accumulating in respondent's motion for sanctions under Rule 26B and C. Petitioner's continued perpetration of fraud upon the court, including falsifying medical evidence. Petitioner's appearance in a separate court proceeding and testimony that she was 24 weeks, due on February 14, 2024, and being treated for a high-risk pregnancy by Dr. McCool and Dr. Higley. Petitioner's failure to appear at a properly noticed deposition pursuant to Rule 57. Petitioner's unreasonable behavior justifying respondent's request for his reasonable attorney's fees and costs consistent with ARS 25-324. All other false and fraudulent behavior revisited in every filed motion / pleading in this matter pursuant to Rule 26B. Respondent's position on these issues cannot be adequately addressed with less than 25 minutes being allocated to each party during the upcoming hearing. Therefore, respondent respectfully requests that this court allow the parties an additional 75 minutes of trial time for a total of 2 hours. Undersigned reached out to petitioner's counsel regarding their position on the above, but no response was received. Exhibit 1. In light of the quickly approaching deadlines, expedited ruling is requested. Wherefore, respondent respectfully requests the court A. vacate the evidentiary hearing scheduled for February 27, 2024, B. reset the evidentiary hearing for 60 days to allow time for petitioner to engage in discovery and disclosure, C. set the evidentiary hearing for at least 2 hours, D. order such further relief as the court deems just. Respectfully submitted February 6, 2024 by Gregg Woodnick. And copies were sent to Corey Keith, Owens' lawyer at the time. Verification. I, Clayton Echard, declare under penalty of perjury that I am respondent in the above captioned matter, that I have read the foregoing expedited motion to continue trial and motion for additional trial time, and I know of the contents thereof that are foregoing is true and correct according to the best of my own knowledge, information, and belief. As to those things stated upon information and belief, I believe them to be true. Signed, Clayton Echard, 2/6/2024. And here we have an email from Woodnick to Corey Keith. Corey, it was nice seeing you on Friday, which I bet is something that he will never say to Gingras. See, he's civil here. So why wouldn't he be doing that to David Gingras? Because David Gingras acts like an asshole. Since we have not received any disclosure from Owens, the RFPs remain outstanding. The HIPAAs have not been executed, provided 3 times. The fetal death certificates provided 2 times, also obstinately not executed, and we still need to dispose Owens after she failed to appear at her deposition. We are going to file a motion to continue and request additional trial time. I assume you agree, but let me know so I can note it in the MTC. Gregg. So this was his Exhibit 1 saying that he let opposing counsel know that he was requesting additional trial time. That is it on this video. Our quote of the day is, complaints and blaming are the 2 main weapons of unworthy people, which is all that Owens seems to do. She seems to complain and blame. And that's all that she can do. But if you like this video, hit the like button. If you want to make sure you're here for future videos, hit the subscribe button and turn your notification bells on, and I will hopefully see you in the next one.